Mr. Kopecky, you may proceed.
Thank you, Your Honor. May it please the Court, Counsel. My name is Eugene Kopecky, and I'm the plaintiff and appellant, and also I'm my own lawyer. And I'm a lawyer. I practiced in Cedar Rapids for many, many years, actually over 50 now. And the issue that is before the court here is really based upon Chapter 99F of the Iowa Code. And I think this court really helped in this case when you decided the exceptional persons case in April of 2016. That was decided shortly before we had the trial in front of Judge Thornhill, and it resolved many of the issues, and I think it helps us in this case at this level also. What happened was that, and the reason that I'm here, is that I asked a question of the Iowa Racing and Gaming Commission and asked for a declaratory order, and that question, I got to read it because it's very specific, whether or not the Iowa Racing and Gaming Commission can use the existence of a gambling license in one Iowa county or the impact on an existing gambling license in one Iowa county when considering whether or not to issue a gambling license in another different Iowa county. The way that came up was that in Lynn County, where I live, we had a referendum that we passed about gambling and approved it by about a 60% vote, yes. And a suitable and qualified applicant filed an application for a gaming license in our county. The Gaming Commission decided that they were not going to issue the license because to issue the license would result in the taking away of profits from existing license holders in other counties, not in Lynn County, but in other counties. When they did that, and I was not a party to that proceeding, I'm not an investor, nor was I an employee or anything in that group. When that happened, it got my attention because I've been interested in pursuing casino gambling in our county since 1990. And I'd gone through many different steps, but this decision got my attention. And as soon as it happened, I grabbed the code and I looked at Chapter 99F to see if they had authority to do that. And I didn't see it. So I thought, well, maybe I missed it. So I waited a day and I decided to read the whole chapter. I read every word of 99F. And after having read that, I was resatisfied, if there is such a word, that I was right, that they had no authority. This was not some criteria that they could use in determining whether or not to issue a gambling license in a different county. Now, 99F, when I look at 99F, the first thing I see is that the legislature did not want any county to have to suffer the throes of casino gambling if they didn't want it. That was left entirely up to the people in that county. And if none of the people in the state of Iowa, none of the counties voted for it, the commission would still be sitting around doing nothing. They have nothing they can do. They cannot initiate gambling, and they cannot put it someplace. They can only do it if the county electorate decides to do so. So the county becomes very important in that. And that's the first thing that I think it says. Secondly, if you're going to have casino gambling in your county, then we want to get part of that action. We want to have state revenue from that. And they set it up. There's a lot of lines in that section, in that code section, that talk about taxes and how much it's going to be. And the taxes are substantial. And in fact, they also put up a licensing fee based upon the counties. Third, they wanted to help economic development. And they talk in this Chapter 99F about hiring and jobs. And so they wanted to encourage jobs when they passed 99F. Now, the other thing they wanted to do was they wanted to make sure that there weren't people coming into our state or people that were already in our state and getting gambling license that had anything to do with the mafia, drug cartels, convicted felons. So they had a list. It's more than 24 things, but because it's in two different sections. 99F4 has a whole list, which is including about 20 items that says if you are any of these things, you don't get a license. And then there's another section under 99F7 that goes into some other things. They even include good moral character. So they do have a lot of rules about that. Now, at the same time, they gave the commission authority to implement that law. And So they did implement the law, and when they did implement the law, and now they decided about all of these criteria, the criteria they came up with here is something that has to be in the best interests of the citizens of Iowa. 99F4, when you're considering licensing, it says that they should consider and give a license to that person. If there are two applicants for a license, they should give it to the person that has the best interest of Iowa in their hearts. So it really comes down, the question comes down here, what's in the best interest of the citizens of Iowa? The commission, by answering my question, yes, what they have said is that the primary duty they have and the primary actions they're going to take is going to be for the benefit of the existing license holders. We want the
concern I have about your position, Mr. Kopecky. I find listening or reading the briefs, I haven't listened to the arguments yet, that they're sort of diametrically opposed positions on both sides. You're saying that the license must issue without regard at all to impact on whether there are licenses in other counties. The state says we have discretion to do whatever we want, and we can consider that as the sole criterion. Wouldn't it be more likely to say that what the legislature intended was something in the middle? That is, the state, the Gaming and Racing and Gaming Commission can consider activities that are going on already in other counties as part of the mix of this discretion that it exercises in whether to issue a license. Isn't that what the legislation envisages?
Well, the real question that I have, though, is what is the criteria? It isn't a question if they're going to issue a license to me or to someone else in a different county. The real question is what criteria should they use? Because I haven't filed an application for a license, and I'm not challenging that they didn't issue it. The question is whether or not they can use this criteria, and by using it, are they acting in the best interest of the citizens of Iowa?
You frame the issue as, can you take into account the impact of a potential new casino in one county on an existing casino in another county? And your answer is no.
Right, that's right.
And their answer is we can do whatever we want. And my suggestion is, to some extent, you can consider it.
Well,
what's wrong with that answer?
Well, because I think we find out that by using this criteria, they are really not considering the best interest of the citizens of Iowa.
Well, but doesn't that depend how it's applied? And let me share with you one of my thoughts, and it's at 50,000 feet, but we've got a history of regulation in our country, and we used to regulate airlines, we used to regulate trucking industry, et cetera. When we did, we had certificates of convenience that were issued, and they were based upon, among other things, impact on the competition. And the view was when we regulate industries is that a factor that you look at is you don't want excessive cannibalization. You want stable markets, et cetera, et cetera. Airline industry the same way. Now we've moved away, on the federal level at least, we've moved away from some of that regulation. But the notion is if you're going to regulate an industry, there's kind of an implication that you don't allow excess cannibalization, if you will. You don't want the market to collapse. Now, I invite you to say, well, that's fine, but the legislature didn't do it. They didn't explicitly do it, and I understand that, I guess. But there's some generalized language about the public interest. They used to give, like I say, certificates of public convenience to have a bus route. I mean, So I think you understand where I'm coming from.
Yes.
Pushback.
Yes. Well, the problem that arises is the consequences of what they're doing, what they did in this case. And it's not conjecture, it's what they actually do. What they're saying is that, we don't really care if the citizens of Lynn County voted for this. We're going to nullify that vote. And they did nullify it. They made it it didn't count.
But the vote is only one step towards the process. I mean, in your view, theoretically, if 99 Iowa counties all voted to approve gambling and lined up suitable applicants, we could have 99 or more casinos?
Yeah, we could have, sure.
Well, you know, if you look at the legislation, I mean, there's no question it gives them the discretion. I don't want to say broad, but the discretion to the number and location of casinos. I mean, the legislature gave them that discretion. Is that correct?
That's right.
Now, in exercising that discretion, the commission came up with, I think, 7 or 8 criteria in order to exercise the discretion about number and location. Did they not? I think that's Rule 491 1.7.
Right.
Those rules have been in effect for over 10 years. Those rules have to be approved by the legislature. They go through the Administrative Review Council, so we have to assume they were approved. Does that cause you any problem that the legislature hasn't really blessed what the Racing Commission is doing?
No, it doesn't cause me any problem, because the issue to me is a little bit different. When the legislature put in the number and the location and the type of structure, I think that's the 3 things in that particular rule that you're talking about, they couldn't determine the locations. They had nothing to say. This commission had nothing to say about locations. They couldn't say, I'm going to go over to Ames and put one in Ames, because the people had to vote for it.
That's not really true, because if you look at the legislation, they did require racetracks in Dubuque and Potawatomi, and Dubuque County and Potawatomi County.
Yes.
I mean, the legislation did require it, so there is some indication that the legislature knows how to require them in places when they want to put them there.
They could have done that. They could have said, we want one in Des Moines, we want one in Ames, we want one in Iowa City. You know, they could have done that. They didn't do that. They said the people will decide where they're going to be, not the commission. The commission cannot put that casino in a location, like they said, location.
If that was the case, wouldn't in 99F7 subsection 11, wouldn't it say instead the commission may issue one or more licenses? Wouldn't it say the commission shall issue at least one license?
They could have said that, but when they said may, they may or they may not, either one. And I'm not saying that they could just get up. I mean, I could file an application and go through the whole process and be a qualified and suitable applicant, and they can look me straight in the face and say, you are not getting a license. They cannot, though, make a criteria that you're not getting a license because you're going to take profits away from the casino 40 miles away and 50 miles away, because that's not in the statute. That's the whole criteria here, is the question, and they clearly can do that. But I think when they say you may not have a license, they have to be able to say that in good faith, that I'm not getting a license because I am not qualified, or I'm not acting in the best interest of the citizens of Iowa. That's where they have to get to. They have to get to that question.
In deciding what's in the best interest of the citizens of Iowa, can they consider the significant investments that other communities have made, roads, infrastructure, to set up a casino, and that the investors in the casinos have made?
I don't think they can. I don't think the 99F gives them that authority because of all the things that happen. I mean, they turned down tax money, they turned down jobs, they turned down licensing fee. It's just a massive argument against that they're doing something in the best interest of the citizens.
Well, can you remind me what happened? Was there a moratorium on any new licenses some years ago?
Yes.
Was that legislative or
no?
What was that?
That was the commission made that decision, and they actually voted on it and said we're not going to take any more licenses.
So they've enacted this Rule 1.7 that allows them to consider the impact on profit of existing casinos. What provision in Chapter 99F in the statute conflicts with that specific rule? Because
that is not in the interest of the citizens, and this law is really written to be in the interest of the citizens, since they give the electorate the opportunity to decide if they're going to participate in the gambling.
The rule does state that when you talk about the economic impact and development, part of the subheadings they consider are the benefits to Iowa tourism, which benefits the people of the state of Iowa, the number and quality of employment opportunities for Iowa. They may want to, not cannibalize a rural casino and take jobs from a rural area and move them to a city area, or the development and sale of Iowa products. I mean, why doesn't it take into consideration the best interest of the citizens of Iowa when those are some of the things under economic impact and development?
Well, I think it does, but it takes away from the real items that are in this 99F. The people decide where they're going to have gambling, not the commission, just the people. And once the people have that decision, then they have to act in the interest of those people, because that's what the code section requires. My time's up. Thank you.
Thank you as well, Counsel. Mr. Ranscht.
Thank you, Mr. Chief Justice. May it please the court. David Ranscht on behalf of the Iowa Racing and Gaming Commission. I have not been practicing law for 50 years, but I sure hope to. I want to jump in with Justice Mansfield. I think you're right. To the extent that my brief says that the is very absolute, that's not really the intent. You're right. We can consider many factors, take into account many factors. The Racing and Gaming Commission could say, you don't get a license because you just filed for Chapter 11 bankruptcy. The Gaming Commission could say you don't get a license because you have a license in Nevada and you've let in too many underage people. We don't want you doing that here in Iowa.
Let me ask you a question about the rules. There's been some discussion about the rules as opposed to the statute. And under RENDA, do we give deference to those rules? Because the language in question says the commission shall adopt rules to implement this chapter. Is language giving the commission authority to adopt rules to implement this chapter? Is that congruent with authority to interpret the chapter, which is what we say under RENDA allows us to give deference?
Sure, it's a factor under RENDA. I think the court has consistently said that the general rulemaking power standing alone doesn't confer the type of authority on the agency that would grant you deference. That's not the only rulemaking provision in 99F. You have that general implement the chapter language in 99F4, but you also have a specific power, 99F4 sub 25, that says the commission shall license licensees of gambling structures pursuant to this chapter and to rules adopted. So there's a specific reference, again, to rules when we're talking about granting a license. That's very important. That goes along with the phrase full jurisdiction.
Just mean procedural requirements or things like, things related to the sorts of things in the first part of 99F6, right?
Well, sure, it could, but it's at the very least a broader reference to rulemaking than just general, hey, implement the chapter as you see fit. And going even further in 99F sub 0.4 sub 13, there's another provision about taking any other reasonable action that is necessary to implement the chapter and do all of those things. And so all of these provisions combined, the phrase full jurisdiction and these rulemaking grants of authority and any other reasonable action kind of really set up the amount of discretion that the commission has and the broad authority that it has to weigh a lot of factors.
Counsel, what specific provision of the statute, 99F, allows the commission to consider the impact on profits of existing licensees in reviewing the application of a proposed new casino?
There's no specific provision in 99F, but 99F, as we've been discussing, sets up this rulemaking power, and the rules kind of elaborate on the criteria. Justice Wiggins, you hit on the notion that the statute says the commission shall decide the number, location, type of casinos. That's a directive. The commission has the power to do that. These rules elaborating criteria that they're going to consider in making that decision are merely fleshing out that directive. The legislature gave them an instruction. You decide the number, location, and type. And the commission said, okay, we're going to put the public on notice. Here's what we're going to consider in doing that. And it's not just the profits. It's the overall stability of the gaming market. That's why they have the ability to put out an RFP and get an independent market analysis. They can consider the Iowa tourism. There's even well, I guess this is statutory, but there's even a notion that if you're going to have a gambling boat, it has to look like a steamboat from the 1800s. I mean...
But if there's a moratorium in effect, which was established earlier, then doesn't that suggest that the only thing the commission is considering is impact on other existing casinos?
There isn't a
not
moratorium.
these other things.
There isn't a moratorium in effect. When you look at it's 491 Chapter 1, 1.7 has all the licensure criteria. You'll see above it 1.6 there used to be a rule-based moratorium. That rule is rescinded. They took that out. But I want to keep focusing here on just the language of the statute. Justice Waterman, you said in the past, plain language can be dispositive, no further analysis is required. That might be as far as you need to go here. You have the phrase full jurisdiction, and you said in Alfredo that means that there has to be some ability to control the economic benefits of the license.
Alfredo, the concern was they were unsavory people who had a shady past were going to be getting the profits from that Dubuque casino. We don't have that issue in this case, do we?
We don't, but this case actually isn't about any particular license application. This is just a pure legal question. It's a declaratory order proceeding. There is no, the declaratory order proceedings don't adjudicate any facts. It's just what is the scope of the authority. And to the extent that this has kind of been framed as a de facto challenge to what the commission did in 2014 with the Cedar Rapids application, it really isn't that. That's not properly before the court.
Can the commission consider, in deciding what's in the best interest of the citizens of Iowa, consider that a new casino in Cedar Rapids would hurt revenues in Waterloo and the Quad Cities and Riverside, et cetera?
It can, and although it's framed in the sense that there's one particular operator that's affected, what this really is, and the minutes, the meeting minutes where they talk about the market studies reflect this. It's a holistic view of the statewide gambling market. So you think of the gambling market as a pie. The addition of a new casino maybe would make the pie bigger and just increase everyone's share, or it would just dice it up smaller. And then we're just shifting revenues from Riverside to Cedar Rapids or to Waterloo or to Dubuque or any of those things. And so there's no real net benefit. It's just kind of playing cups and moving around the same money that's there.
Well, let's explore Mr. Kopecky's argument, as I understand it, at least, and that is that this statute is fairly detailed, at least in some places. I mean, there's a lot of fine print, a lot of provisions under, was it 99(6)F. It is not a kind of a generally framed statute. I mean, it looks like the legislature knows how to be pretty specific, and they've written a laundry list of criteria, and it's fairly dense. Now, if the legislature really wanted to have this kind of intrusive economic regulation, wouldn't they have said so? I mean, when they're writing a fairly detailed statute?
Well, I have two responses to that. And the first one is the language of the statute, kind of the syntax that's there gives you their intent. And the language says you shall not get a license unless, right? There's kind of a presumption against licensure. Gaming license is never a right. It's always a privilege, and applicants understand that when they submit an application. They have
I guess,
to
but
swear to it.
don't you agree with me? It's a fairly detailed statute.
Sure. It's a fairly detailed statute, but so is 422, so are all the tax regs. And this court said in City of Sioux City versus the Department of Revenue and Finance that there was still, the authority on behalf of that agency to go ahead and promulgate additional rules. I mean, I would say tax is even more dizzying than this, and there's
could be. But let me just go one step further. Yeah, surely right. I mean, surely you have a laundry list of 26 things or whatever, and the legislature may say, well, there's a 27th or 28th, and we're not going to foreclose rulemaking. But again, what I hear coming out of Mr. Kopecky in part, and maybe I'm putting words in his mouth, and he can come up and correct me on rebuttal. But this particular position that you're taking is very muscular. It vests authority in the commission to extensively regulate the economics of gambling, and if the legislature really intended that, rather than a less regulated approach, they would have said so.
the legislature did give the broad authority. I understand that this court sometimes gets some heartburn about putting too much stock in administrative agencies and letting them do too much, but all of the language used, the full jurisdiction, all of this rulemaking authority, even the phrase in the statute that the commission shall issue a license if it is satisfied. It put the agency's satisfaction into the statute as a criteria that the commission can consider in making a licensure decision. It is really what the legislature intended here. There has to be some oversight there, and it's really a pretty good system that the legislature wrote into the law here. We've got the check on NIMBYism, right, by allowing a county to say, hey, no, we don't want that. And in fact, as you can see at Appendix 2, Lynn County said that in 2003. They said, hey, no, we don't want a casino here. And so just as a matter of historical perspective, that's what led to the casino in Riverside. And it's almost, I don't mean to be too flip here, but they missed the boat, Lynn County did.
And you've been doing a very good job of answering questions. So let me throw one more at you related to what you just said. Mm-hmm. Isn't there a public policy argument against the interpretation that the result is counties that are sort of first in, that don't miss the boat, as you put it, end up getting significant additions to their coffers or to their communities, and others don't, and that seems somewhat arbitrary, doesn't it?
It's not
is that
really.
Really what the legislature intended?
It's not really arbitrary because it's not a final determination. The 2003 referendum was one thing. The 2013 referendum was another. The market study said in 2014, hey, the market can't really bear another one. It's pretty saturated, but population can increase, population can shift around, demand for gaming can increase. The economics are just kind of a lot more complicated. It's not that there's $200 million just sitting out there that we need to come grab.
That's my concern with your argument here. Mm-hmm. The statute does say you have to have racetracks in Dubuque and Pottawatomie County, regardless of the economic impact on the other casinos in the area. Mm-hmm. The statute also says that when you have a racetrack, you can't have a boat in that county unless revenues are over a certain amount. Mm-hmm. I think that's 99F7-2. So the legislature has things about economic development and about economic cannibalization. Mm-hmm. But now your rule goes further than the 2 or 3 specifics that are contained in the legislation and says we're going to apply that statewide. I mean, does that seem inconsistent where the legislature says where you want to look for cannibalization and where you don't, and all of a sudden your rule goes statewide?
No, I don't think that's inconsistent. And if you've been following kind of the gambling industry, there are no longer requirements for live racing in Pottawatomie County or Dubuque County. That's kind of fallen away, right? There's a separate Dubuque racetrack now, and the legislature does. It makes a few particular directives and says, hey, there shall be this here, there shall be this here. It also says there shall not be any. There's the gambling games prohibited area, which is down 14th Street around Grace Lake. There shouldn't be one in the city limits.
They do make determinations in the statute, specific determinations about economic cannibalization. How can the Racing Commission go farther than that? How can we find that authority? Isn't that arbitrary then?
It's not going farther. It's just kind of expanding upon it. I mean, it would be a direct conflict under that exceptional persons case if the commission said, "Oh no, we are not going to put a licensee in Dubuque County, even though you've directed one." It would be a direct conflict for the commission to say, we're going to build a casino on the shores of Grays Lake, even though that's within the geographical area that the legislature has said there's not going to be one. Going beyond and just doing additional things doesn't create a conflict. There's no direct head-to-head, and that exceptional persons case just doesn't really help us. Where it does help us is in just the general statutory interpretation language, where we say, okay, look at the plain language. Well, the plain language is full jurisdiction. The plain language is rule-making power. The plain language is shall decide the number, location, and type of all casinos. The plain language in the referendum provision is may. And this court has repeatedly said that the may is just a discretionary power. That valve doesn't work two ways. It's a condition precedent. The commission can't put a license in a county unless the people approve, but it doesn't go the opposite way in that a county can force the commission to do anything.
Should we look to decisions of other states? I mean, gaming has proliferated nationwide, and there are decisions in Pennsylvania, New York, maybe other places that hold that under similar statutory schemes, the regulators can consider market saturation in evaluating applications for new gaming ventures. Should we consider those?
Yeah, you can consider those. I think that they're just consistent with what the general law is in this industry. I mean, the Drake Professor Miller wrote the book on this literally, and even in the book there he says generally regulators consider all of these things. And I cited in my brief several statutes from other states that just kind of lay out, look, the discretion in licensure here is very broad. So I'm going to end here where I end in the brief and say that the statutory language is very strong. Commission may issue a license after a referendum, not required to. And the commission, not the voters, shall decide the number, location, and type of casinos. You should affirm. Thank you.
Mr. Ranscht, thank you as well. Rebuttal, Mr. Kopecky.
Thank you, Your Honor. Judge Apple, that is my position, the one that you spoke of there. But I think the thing that's been unsaid in this argument, and it's my fault for not saying it, but you know, what they really have done here is grant regional licenses, and the commission should have gone to Riverside or Waterloo or whatever and say, look, you know, we're going to give you 4 more counties, but for those counties you got to pay $5 million if they have 15,000 people or less, $10 million if you got 15,000 to 100,000, and $20 million. And then at least they would be honoring the statute, and they would be bringing revenue back to the state that the statute says they should have. 99F says if you have a license for Lynn County, for example, it's a $20 million fee. If they're going to give the licenses for Lynn County and Johnson County and all the counties around there, they better add those up, and they better ask those people for it, because that's a violation of the statute. And they are talking about regional licenses. They're saying, we're going to grant you, this is too close. They're taking too much away, the profits from them. And so it seems to me like that's a direct violation of this 99F. They also, how they could give up revenue to the state, that part helps every citizen in the state of Iowa. At least that's my general feeling that it would. That's in the interest of the state, to collect more revenue from people that are willing to pay. I mean, the gamblers, they go in and they gamble and they're willing to pay. And clearly under plaintiff's affidavit number 4, I spelled out in detail the amount of money that the commission has decided the state doesn't need by taking their position. You know, it's a lot of money. It's more than $200 million over the first 10 years. That's money that all the citizens of the state could use. So it seems to me like they have their position, but their position is not in the interest of the citizens of Iowa. And they demonstrate it by their own actions. It's not conjecture. It's actually something that they've done. It's shown in the minutes that I've attached that are part of the record, and it's shown in their statements in their meeting, and it's shown when they answer this question, yes, then they've made those decisions. They've also decided that they do not have to honor the citizens of the county that made that decision. That's a nullification. And that's certainly not in the interest of the citizens of Iowa. So I have nothing further. Thank you.
Thank you as well. The case of Kopecky versus Iowa Racing and Gaming Commission is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.